Good afternoon and welcome. And in the spirit that Ron invoked and Robert O'Neill invoked, I will wish you Céad Míle Fáilte, which is 100,000 welcomes in Irish. I want to thank Jean and the First Amendment Center and James Hoff and Ken Paulson and the Freedom Forum for making this opportunity available. I also want to thank Ashley Hampton and Megan Sims and Brian Buchanan, our volunteers, and all the people there who are, I know I don't know everybody's names, who are making this possible, all the people behind the scenes. So let me tell you a little bit about OpenTheGovernment.org. We are a coalition, and actually if my panelists and moderator can come up and start joining the stage as I'm introducing you. We are a coalition of 80-plus organizations, about half of them state-based, that work to promote openness, mostly at the federal level, the coalition does, and to push back against secrecy in government. So we work on a wide range of issues. FOIA is only one of them. We also work on trade secrecy that you heard about this morning. We work in partnership with our colleagues on whistleblower. We are working currently on national security issues. And the reason that we have chosen these panels for today are because we think these are where the Obama administration is most vulnerable, where they have been the least open, particularly on whistleblower issues, and particularly where it has to do with national security whistleblowers. But also, it's a sense of our community that the national security state, the national security agencies and the law enforcement agencies that deal with national security information seem to be in a bubble that are impervious to the openness initiatives of the Obama administration. And where the administration has actual control, they've done some good stuff. They've released our information about our nuclear defense posture, information about our stockpile. They're trying to look to reform the classification system, but there's a lot of problems. And so our two panels today are going to address a range of those problems. So let me first introduce our first panel, and I'm going to go alphabetically, and I think we're going to be joined, well, I know we're going to be joined by Skype. I think it should be up momentarily. Gary Aguirre is a former whistleblower himself, and he represents whistleblowers from the financial industry. Hey, Gary. And the government agencies that regulate them in judicial, administrative, and congressional proceedings. Tom Bowman, okay, is NPR's Pentagon correspondent since 2006. Previously, Tom was with the Baltimore Sun. He covered the Pentagon, the U.S. Naval Academy, and the National Security Agency. He's received an Edward R. Murrow Award for his coverage in Afghanistan and shared in a National Headline Award for detailing the delays in fielding combat tourniquets. Mark Cohen is Deputy Special Counsel of the U.S. Office of Special Counsel and formerly served as the Executive Director of the Government Accountability Project, which works with whistleblowers, and is an award-winning documentary film and TV producer. And again, I'm doing this alphabetically. Lucy Dalglish has been the Executive Director of the Reporters Committee for Freedom of the Press since 2000. She's a former newspaper reporter and editor and a former trial lawyer in Minnesota. Abby Lowell is a partner at Chadbourne and Park, where he heads the White-Collar Defense and Special Litigation and Investigations Group. His practice focuses on the investigation, trial, and appeal of complex and often high-profile criminal and civil cases throughout the United States and counseling clients with respect to dealings with legislative and government agencies, including cases involving allegations of government leaks, the FOIA, and defenses based on the First Amendment. And last but by no means least is Matthew Miller, who is a partner at Via Novo, which is a consultancy. Before joining Via Novo, he served as the director of the Office of Public Affairs for the Department of Justice from 2009 to 2011 and served as Attorney General Holder's spokesman. He has worked in leadership positions in both the U.S. House and Senate, serving as a communications director for the House Democratic Caucus and the Democratic Senatorial Campaign Committee. So with those introductions, I welcome our panelists and turn it over to Abby.
Thank you, Patrice. I'm sure you can hear me. I don't know if you can hear me because of this or because of this, but as long as it's not feeding back. And Gary, can you hear us?
I can.
Great.
Can you hear me?
Very well, and I'm glad you said something so we could tell. So let me frame some of this and then get right to the folks who know. This last week alone, the following events have been occurring, all of which I know you've read about or you know firsthand, in no particular order. There was another court appearance for Bradley Manning concerning allegations between his providing information to WikiLeaks. There was the op-ed and the fallout of the op-ed of Greg Smith talking about the culture at Goldman Sachs. There was the lawsuit brought by Joe Insignia about the IRS for failing to provide him with his just rewards for having been a whistleblower concerning IRS lack of enforcement in tax havens abroad. There were events in Jeffrey Sterling's case concerning CIA issues. And this was all within the last, 7 or 8 days. So what's going on? Is this the continuation of a trend? Is this a new era? Do we have more people that are involved in providing information outside of the bowels of government into the public? Is it sort of the good old days, the bad old days? Is it Orwellian? Is it a blip on the radar screen or not? That's what I think part we're going to explore today, and some of the issues that I think these issues raise. I'd like to make sure that we're speaking from the same frame of reference, so let me throw out 5 or so cases, and you all then can either add to or subtract from before we get into questions. We all know about the Thomas Drake case. It was very much on the agenda last year. You know, of course, that was his attempts to deal with the Trailblazer program, analyzing whether the NSA was wasting funds in this effort to deal with Internet communications and the like. After he had done that on whatever he felt was the schedule that made sense for him, he was indicted under the Espionage Act that went on for some time before a relatively minor deal was worked out and the government dropped its most serious charges. Now there is the case of John Kiriakou, the CIA officer who is alleged to have provided information concerning the enhanced interrogation programs, and he too is the subject of an Espionage Act prosecution. There is my client, Stephen Kim, a former official at the Department of State, who is alleged to have provided information to the media about what was going on in North Korea in retaliation for United Nations sanctions. There are the case of the FDA-9, the group of scientists who exposed the flawed process at the FDA, what they said was the flawed process on approving various devices, and the suit they've now brought about the retaliation that they faced with spyware being added to their personal accounts on their computers, and an OIG investigation that resulted from what they did. You've all read about the issues of the disclosures of the way that troops were being greeted back after they had died in combat at the Dover Air Force Base and what was happening at the Arlington Cemetery. Gary is on our screen, and he's a very well-known case about his efforts to deal with the SEC's reluctance to go after in earnest the investigation of Pequot and what happened after that. It's the case of Franz Gale, long ago but not so, in which he was talking about whether or not the government was doing all it could to provide protective gear to our military abroad, and the alleged allegations of retaliation based on his losing a security clearance over his using a thumb drive in his computer. And I guess recently I mentioned Greg Smith at Goldman, and I should be remiss if I also didn't say that it's not always on the military side and maybe not always on the national security side, but in the last few weeks we saw the book written by Gary Dampo, who was the Interior Department person who blew the whistle on the way the Interior Department had provided special attention and permission for business person and NFL Redskins owner Dan Snyder so that he could chop down trees on his property, and what happened to him going from being a deputy ranger to being in charge of giving permits for picnic tables in Alexandria, Virginia. That's just some of the range of topics, and I'm sure the panelists can do others. But I wanted to make sure I reminded everybody of at least the case law, or at least the common law of what we're talking about these days when we talk about the concept of what we call whistleblowing. Before the first question, let me just remind all of us of some of the government responses to all of this. The former Associate Deputy Attorney General of the United States Attorney in the Eastern District of Virginia, Neil McBride, in discussing the cases that were brought under the Espionage Act, said, "The law simply does not allow one person to unilaterally decide when and if and how to provide disclosure of even interests that the public may have." And a Department of Defense spokesperson said, "The difference in these cases, of course, is the difference between being a whistleblower and a common leaker." So with that, let's start down the road. From some government perspective, Matt, what's the difference between a leaker and a whistleblower?
Well, I'll touch on the national security cases because I think it's easiest in those cases to tell the difference between a whistleblower and a leaker. I think, a whistleblower in the classic sense is someone who exposes government wrongdoing, exposes waste, fraud, and abuse. A leaker, a whistleblower can be a leaker, but I would argue that not all whistleblowers not all leakers, and certainly not the leakers, most of the leakers who have been charged with leaking classified information are whistleblowing. At least if you look at the 6 that have been charged during this administration, I think one, Thomas Drake, you can make a credible case, was trying to blow the whistle on what he saw as wrongdoing. The others, I think, in some cases you can make a credible argument, not one that I accept, but you can make an argument that they were trying to blow the whistle, but others you can't. John Kiriko is a great example. If you look at what he's charged with, it's not that he exposed information about the torture program that happened overseas during the last administration. That was exposed long ago, and in fact, no one has ever been charged with the leak of that information. What Kiriko is charged with, among other things, is exposing the classified identity of a covert CIA operative. Something that, if it had been published, could blow that person's cover and potentially endanger their life.
Mark, let me ask you the same question, but with a slightly different slant. From the perspective of the OSC, when you are reviewing whether or not somebody has done an act for which there should be protection or there's been retaliation, where do you, or how can you, and the rest of us, define that line where Matt says between somebody who is a leaker and somebody who's a whistleblower?
Well, I think the key is whether it is protected activity or not. And if you disclose information that reveals waste, fraud, abuse, or gross mismanagement, gross waste, or a threat to public safety or security, then that is a protected disclosure, and it will invoke the protections of the Whistleblower Act.
Will it matter whether or not the source of that information that theoretically exposes waste, abuse, and fraud is about something that's classified versus something that's not classified?
Well, let me just talk a little bit about OSC and how we deal with that. We can take classified information from people who come to us with those concerns. We're not going to do it through insecure channels, and our website is not the place to send us that kind of information. But we will take classified information from people. On the other hand, if it has to do with foreign intelligence or counterintelligence, and it has something to do with if it is prohibited by law, we don't look at it. We just turn it over to the National Security Advisor and to the select committees on the Hill. So I'm not sure that there's a great advantage to bringing it to us in those circumstances. And in terms of a prohibited personnel practice or retaliation matter, if somebody wants to bring those to us, if they are part of the 17 agencies that are identified as dealing with foreign intelligence or counterintelligence and their jobs are related to that, we're not able to take those cases.
I'll come back to the issue of between what's classified and not in a second, but I want to ask Gary. Hey, Gary, should there be different rules as to how an employee of an agency should act up the chain to determine whether or not they've gotten to the point where they have exhausted their internal remedies, depending on whether it's an agency that deals with the trees around Dan Snyder's house, or who the covert operatives are in the war zones of the Middle East?
Well, in the cases that I've been handling, what I find is very often the whistleblower is blowing the whistle on his supervisors. So what happens is the subject of the whistleblowing is the residuary of agency power. So in blowing the whistle and going up the chain of command, he's really blowing the whistle to folks that are involved in the reprisal. And I see this time and time again. In fact, I had that same experience at the SEC, because I learned that when I was blowing the whistle, I was blowing to the whistle who had made the person who had made the decision to stop the investigation because of the influence of the person that we were investigating. So I think that there are channels out there that exist, and I think that's what's critical. What I think of as safe channels. And one safe channel is the Office of the Special Counsel, because you can communicate with the OSC regarding confidential matters. If you blow the whistle beyond confidential matters, that are not confidential, you can go to the media. That's a safe channel. You can go to the Congress, I think, under the Lloyd-La Follette Act. So the key is, where are the safe channels? Where can you safely communicate this information to somebody that needs to know about it, that can fix it?
Lucy, does the distinction that people want to knee-jerk, I don't mean knee-jerk in a pejorative way, so let me change that, is the distinction that seems intuitive between when a whistleblower is dealing with national security or classified information and none. Does that put too much power into the hands of those who classify, given the low threshold it takes to get something classified?
Yes, I think it does.
All right, moving on from that question. Well, what do you do about that then? Because, see, the government has a, on paper, perfectly legitimate point to make, which is that some information, whether it's in the context of operations or whistleblowing or any other, has to be treated more closely. That makes sense. Nobody would deny that. Nobody in this room or any place, I suppose, would. The problem then becomes when the rubber meets the ground, because, as we all know, if everything and its sister is classified, and we all agree that there's way too much classification, it then almost puts those who operate in classified information in the government who want to stifle people coming out, people being dissenting, people exposing waste, abuse, and fraud. It puts them in more power than the folks at the Department of Interior.
Well,
right?
I think that it has become far more dangerous in the last few years to release something to the media than it ever was in the past. When I first moved to this town and would have conversations with people in whatever administration it was, Bush or Clinton, they would acknowledge that under some circumstances, the leak of information that may or may not be classified could be a good thing, that the public might benefit from the release of that information. In the last few years, I don't know if it's because of the potential for release of information via the internet, a la WikiLeaks, or what the actual problem is, but there is far less of a recognition of the public value in releasing information by public employees to the media. There was a conference I was at last summer. The rules of the conference were thus. There were a whole bunch of senior-level intelligence agency officials, several high-profile journalists, some of us in the news media, First Amendment law realm. The rules were we could say what was said, but not who said it. So this is where it's coming from. I was told point blank, you know, after WikiLeaks, there was basically in the intelligence agencies a take-no-prisoners policy. You leak national security information, you will be prosecuted. End of story. No more judgment call here, how bad was the leak, how was it not. The other thing I'd point out is last year on FOI Day, there were a number of us here in the room, Patrice included, Danielle Bryan, Gary Bass, Tom Blanton, and myself, made sort of an attempt to get to the White House to meet the president. The meeting finally came off a couple of weeks later. But it was interesting, Danielle, who can elaborate on this perhaps later in her appearance, she's the one who brought up the issue of whistleblowing to the president. And that's the time he kind of leaned forward. Patrice probably remembers this, and Danielle has written about it on her blog. He leaned forward and said, I want to talk to you about that. And my interpretation of what he said was, I understand there is a need for people to be able to freely come through the system, through the channels, release information. But if you release national security information, that's a totally different story. You will be treated entirely differently by this administration.
We'll come back to the issue of that sort of raises what I was trying to ask, and there's probably not a good answer to it, which is, what did the president mean by national security information, and whose definition is it, and who gets to apply that definition, and does it get applied after the fact, and therefore you find yourself on the what I like to say in my world as the wrong side of the V between United States versus whoever it is, but the wrong side of the V. Tom, as a journalist, do you care what the difference is between a leaker and a whistleblower when the call comes in, because either way it's going to be a good story? And do you have different rules depending on what agency that person is from and how you deal with it?
I think the terms would mean more to the OSC than it would to a journalist. Leakers and whistleblowers, it means nothing to me, those distinctions. And I would like to point out this issue of overclassification. Daniel Patrick Moynihan, as many in this room know, wrote a book about this, I think 25 years ago, about overclassification. We've seen that repeatedly. In this notion of national security, don't release anything about national security, would that include the story in the New York Times this week about some officials saying they wanted to reduce troops faster in Afghanistan from a White House official? Now, is that official going to be talked to by the president, I wonder?
No, do you think maybe that official the president told that official to do that?
That's quite possible. Here's the other thing. You know, we couldn't do our jobs without leakers or whistleblowers, whatever you want to call them. We've had whistleblowers throughout our history. You could argue that Martha Washington at Valley Forge, talking about the conditions of the soldiers, was a whistleblower. And to bring it forward to stories I've worked on, a woman at NSA told me about the lack of women and minorities on the staff at NSA. She came forward with that information. We were able to write stories on it when I was at the Baltimore Sun. A Pentagon investigation ensued, and things changed at NSA as a result of those stories.
Let me pursue the one part of the front part of your answer.
One last point, too, as far as overclassification. Everybody heard of Abu Ghraib, right? Remember the report they did on Abu Ghraib, general named Taguba? Mm-hmm. That was marked top secret, no foreign dissemination. I defy anyone in the administration or the Pentagon to tell me what in that report, you know, should have deserved a top secret classification for that report. The reason that was top secret, no foreign dissemination, because it was an embarrassment. Had nothing to do with danger to national security. That's the kind of thing we see day in and day out.
Well, on the point that you just made and the point that others have alluded to, so put a bookmark as to the meeting you had with the president. Again, viscerally, it sounds right. But if you are dealing in national security information, well then, ... But then the question becomes, why is it national security information? And the problem there is like the Supreme Court's decision in the obscenity cases, telling a would-be defendant, we know it when we see it, doesn't provide necessarily the best protection. One more point, though, Tom, I want to just keep following up on this. So from the recipient's point of view in the media, putting aside whether you're egging anybody on for a second, when somebody calls, you don't make the distinction. To you, it's a source within the government providing information that may have newsworthiness, without regard to whether or not it is agency X, agency-wide. I know you might think of it differently depending on whether he tells you I've got a classified report in my hands, but given your statement about what gets classified, not so much. So he's worried about whether there's a distinction as the person who has to defend. As the recipient, you don't care very much, and you already start seeing the tension that exists when we have conversations between between people in the government and people outside the government. I don't know that we can resolve that, but it's important to make that distinction. Maybe I should have started with a more fundamental question, and I'll start with you again, Matt. Is whistleblowing an essential component to our democracy?
Absolutely. It's an essential component to exposing things the government does in its citizens' names that it shouldn't be doing. And it's something that the government should encourage. I know when I was at the Justice Department, it's something we encourage, not just for government employees who are whistleblowers, but for private employees who are whistleblowers. You look at the KETAM statutes, which allow the government to reap enormous benefits, enormous revenues when someone blows the whistle on private waste, fraud, and abuse that costs the government money. A lot of the Justice Department's best investigations come from people who blow the whistle on wrongdoing.
So, Gary, let me ask you this. Everybody can again use the word whistleblowing, and all probably concur that it's, as I called it, an essential part of our democracy. How do we then define how many steps a Gary, a Tom Drake, Kyriakou, how many steps do they have to take inside before, I suppose, the phrase whistleblower means that you've gone outside? I guess we can use that as a common definition. You're not whistleblowing if you tell your immediate supervisor that he's a jerk, right? You're not whistleblowing if you tell the supervisor above the supervisor that the supervisor was a jerk or doing something wrong or wasting a fraud or whatever. How many steps? And does that change depending on whether you're at the SEC or the NSA?
That's a terrific question. Let me tell you
That's the only one so far? Sorry.
I don't think anybody wakes up in the morning and says, today I'm going to become a whistleblower. I think it's time that I become a whistleblower. What happens is that you face an issue. You confront an issue. You're asked to do something. And it puts in conflict what you're obligated to do, perhaps under oath, in the position that you're in, or to comply with somebody above you. You make a decision what you're going to do. Now, in my own case, when I faced that conflict, my first reaction was to back down, walk away from it, because it wasn't my fight. It nagged at me for a while. And then finally, I confronted it with the first step. The first step was internal. It was with my immediate supervisors. And then I went up another notch to the next step. Finally, at the SEC, the only notch left was the chairman, was the commissioner, the chairman. And at that point, I was fired. So the question that, when do you become and then I went to Congress. So that line from my supervisor to his supervisor to the head of the enforcement division to the chairman was a progressive line. There was never a moment that I thought, my God, I'm a whistleblower. I was just taking it up to the next step. And eventually the next step was the Congress. Now, it's been classified, people look at it as, well, he became a whistleblower when he went to the Congress. But that's kind of an arbitrary line, because I consider the entire sequence, every step that I made was part of the same process. From a whistleblower standpoint, after you've taken it up 5 levels to 4 or 5 levels to supervisors, and you're facing the reprisal that comes with it, you have to go on to the next step.
Let me identify what I bet is going to be another distinction. Mark, when you're looking at a person who is in the process or claims to have been retaliated against, I bet it matters to you. It is relevant. It's part of your inquiry. How many steps, what steps were taken before that person finds him or herself on the front page of some newspaper, right?
It is relevant. It's relevant because the law says it's relevant. Right now there's a limitation in how the courts have interpreted the whistleblower statute to say that if it's part of your job duty, then you're not protected. I don't think that makes a lot of sense, and part of the reform that's being proposed under the Whistleblower Protection Enhancement Act is to remove that restriction so that when an auditor finds wrongdoing or a safety inspector finds wrongdoing, and they report that to their supervisor, that is protected activity. It should be protected activity. The only circumstance I can imagine where it shouldn't be protected activity is if you already know that that's the wrongdoer, and you're just telling them and you're getting in an argument. Maybe that's not a disclosure. But if you don't know that, anywhere in the chain, I think, is a disclosure and should be protected activity.
So to put a fine point on this, Tom, doesn't matter to you how many steps the person tried to take before they called you on the phone, does it?
I hope I'm the first step.
Right.
Yeah.
And so consequently, again, look at the tension that exists between those who are gathering and those who are disseminating. Does it matter to your story? Does it matter to your story? If I called you, if Tom Drake had called you, or Gary had called you and said, I tried this way, this way, this way, this way, or just, by the way, there's something very flawed in the way the SEC is doing X or where the National Security Agency is doing Y.
No, I think it's definitely part of the story. If this person goes up 3 or 4 or 5 or 6 levels to try to resolve this problem inside and is not heard in his or her agency, I think it's definitely part of the story. You know, my immediate interest, is it a compelling story and is it true, of course, and how can I verify this information? You always like to have a nice report, nice piece of paper, like we did have with the Taguba report, which, by the way, was leaked to several people. Thankfully, I was one of them a number of years ago. But, yeah, it could be a big part of the story as you move forward with this.
Lucia, I've lapsed into the area of the media, so I want to pursue this a moment or two at least. What's the media's, I use media, you know, big box, big M. What's the media's role in encouraging, well, let's just start with this, encouraging. What's the media's role in encouraging people to call Tom on the phone? And when does the media's role then become, if at all, antithetical to the whistleblower's role? By that I mean, Tom doesn't much care. This whistleblower is likely to lose their job, be on the wrong side of the V, and who else knows what.
I've never met a reporter who didn't care about that.
And we don't necessarily have to use a person's name, by the way.
So we'll get, tactically, we can discuss in a,
right.
But what about creating the culture, the milieu, the frame of reference by which people are encouraged to become whistleblowers? Media was involved in that, or is it just the nature of the fact that we're all so more well-read, more so internet accessed, that now it seems like there's more?
I think there's always been encouragement by the media to get sources to come forward. There's always been some people who will want to believe they have no other alternative. Certainly the internet has changed that. These, you know, post-it sites, WikiLeaks being obviously the best known site, encouraging people to sort of come forth with information and secrets, and there is sort of an exposure culture we have here. The one difference I think you would have when you are dealing with more traditional media and, dare I say, older reporters, they generally, I think, have a better idea of what the consequences might be for the people who do this. They also have, they used to also believe that they can protect the leakers. I don't think they can anymore.
I mean, I want to stop there. It's such a great point, Matt. I mean, think about it, the irony, and well, irony may be the wrong word, but think about it. In a certain way, the ready access that a would-be whistleblower has now to post her or his own whistle, or to get on and, because we all sort of hear about it, get there, may provide less protection to the whistleblower than when he or she engages with Tom or you, and you can talk through the right way to do it, how it might get exposed, how you might protect it. It is actually a very interesting notion. When did you ever think that the media was going to become the filter by which information out of the government gets disseminated to the public? But in a very real way, you're pointing that out.
Yes.
Well, I would add one thing, too, in that it also provides less protection for the government in a way. One of the things
I'm sorry, be clear, which provides less protection?
The fact that people now can either post information themselves or leak it to bloggers. One of the informal checks and balances in the system that we have is many occasions when a media outlet receives a leak, wants to publish it, the government prevails on them. It happened in the Sterling case with the New York Times editors, but there are many others. Happened times when I was at the Justice Department. You go to either a reporter or to his or her editors, and say, look, here's why, and you often have to tell them something. Here's why, if you publish that, while it may be an interesting story, here's what you'll damage, and you ask them either not to publish it or to wait a week or to withhold certain facts. And responsible, news outlets will make their own judgments, balancing the need for people to know, balancing real national security harms. But oftentimes they will withhold things or delay them in a way that's responsible, and you just don't have that kind of ability to interact with someone with someone like a WikiLeaks.
Gary, is there now a place for, is the idea of whistleblowing that we all recognize as being an inherently government event? I gave a couple of examples when I was setting up the framework. Is that a phenomenon in the private sector now as well, as in the Greg Smith Goldman? We could talk about others, but that's the most recent.
Well, absolutely, and they merge. The concept of a private industry whistleblower and a government whistleblower can merge. They can be talking about the same thing. Under the Dodd-Frank Act, the Congress basically deputized everybody in every financial institution and public company to be a whistleblower. It incentivized them to speak out against securities violations and protected them if they do so. Now, what's happened is that those kinds of communications to government, a whistleblower with, say, a Fortune 500 company, goes to government, goes to the SEC and says, look, this company I'm with is making bribes to foreign officials in Mexico. We think you ought to investigate it. What does the government do with that? Government goes back to the company, allows the company to select a law firm that it's cozy with, and then that law firm conducts the investigation. Essentially, the government outsources the investigation to the private law firm of a Fortune 500 company. Now, you've got a whistleblower on the inside who's talking about it. Maybe there's a whistleblower inside the government that knows about it. So you have potentially whistleblowers from private industry who are talking about corruption in private industry, which is reflected by a different type of abuse inside the agency itself.
Mark, can you get to the point, not you, can we get to the point with Dodd-Frank, the Foreign Corrupt Practices Act, the financial incentives that are provided in which the government is doing too much to basically encourage the release of information because people now have a financial reason to do it as opposed to a, quote, good government reason to do it? Can they ever get to the point that the government's gone overboard?
I suppose it's possible.
We're not there yet?
But I think that if you look at the amount of what is being reported when we use these statutes, what's being found, the amount of the billions of dollars that are being recovered for the government, it's an indication that there's a lot out there, and it's probably the tip of the iceberg.
Lucy, what do you think? Do you think that, if that line exists somewhere, we're certainly not there yet? I mean, in terms of whether or not there's this too much have been provided incentives for or not?
Incentives for people to leak or non?
Well, I'm not using the word leak, but leak is as good as any. I mean, have we gotten to the point where now it's not the same? I mean, somebody who takes the, quote, principled course of deciding that something is so amiss in a government agency to take the risk to his or her own career to report it, as opposed to somebody who sees, I get 10% of $100 million? That's what I mean.
Yeah, I got to tell you, in this day and age, with everything we can do with technology, 10 or 15 years ago, if I were a government employee or privy to some sensitive information in a corporation, and I felt that I had nowhere else to go, I probably would have considered going to the media. I don't know that I would anymore, because the Reporters Committee was founded 42 years ago on the issue of protecting sources. And back then, as a reporter, you could protect your source. These days, you really can't if you are using any type of technology whatsoever. If you are emailing your source, if you are using credit cards to go visit your source, if you are telephoning your source, if you are leaving an electronic trail, they will know how to get you, particularly in the national security realm. And the notion, I mean, Bob Woodward was able to protect Mark Felt for, God knows, 35 years. Why? He used the technology of a flower pot, a balcony, and a parking garage. And these days, I'm paranoid. Okay, I'm just totally paranoid. If I'm going to, if somebody gives me information, I'm just going to tell them, hey, keep in mind, they probably are going to figure out who you are. So be
that
prepared.
being said, some of us still do meet with sources in bars and restaurants, and not on the phone or emails.
Yeah,
for that
because
very
you know
reason.
what you're doing. Yeah.
Well, we've
And,
got
I
to
got to tell you, if I were in government, I would never talk to a reporter on the phone or through email.
Ever.
We've gotten to this point, and I'm going to take this out of order because you're there. You're there 2 questions perhaps before I would have wanted to, but I think it's such an important point. Let's take it on. There are so many cases now that I just started reeling off in the beginning, and I'm not the first, and this place here is not the first forum in which it's been pointed out how many Espionage Act prosecutions there have been, how many other allegations of retaliation against whistleblowers there have been. And people said, well, why is that in 2010, 11, and 12? And why is it in an administration that people would have thought, I suppose, would not have been the one to be the most active in this area? One answer is always given when that's asked, which is we can figure out who the leakers are now. There are other reasons, but that's one. So have the tactics changed, Matt? I mean, from the point of, I mean, the Justice Department has its own set of Code of Federal Regulations. And there is one that always has existed since I was there 122 years ago. And that one was the extra protections before you would subpoena somebody in the media. However, what we now see, whether or not that's being tripped or not, media having their phone records gotten, their email records gotten, and other such things. Is that the difference? The tactics have changed?
First of all, I would separate the media subpoenas from the other tactics used in investigations. I think media subpoenas are, as you said, there's an entire set of regulations that exists around them that make them much more difficult to use, and have only been used really in one of the 6 cases that the administration has brought. I'd say in general, one of the reasons I think why you've seen more cases, there is a perception inside the administration, also on the Hill, ironically, that there's more leaking going on right now. And I don't know whether that's true or not. I'm sure people that served 20 years ago would say it's not, but there is a perception there's too much leaking and that something needed to be done to crack down on it. And then I think on top of that, it's easier a lot of times to catch leakers than it was when you would just meet in a parking garage to give someone information. If you look at the Kirikow indictment, he is alleged to have leaked this agent's identity over email, which is not very smart and pretty easy to catch.
Mark, is that the case that the difference is now is that there is, you think, more leaking by whistleblowers than there used to be? Or is it just that we have more means by which to do it?
I don't know, quite honestly.
Do you have more business than you did?
I can tell you that our case load has risen dramatically, that since 2008, when we had about 3,100 cases before our agency, today it's up to about 4,100 cases. That's a dramatic increase. The number of disclosures in the last year have risen by 33%, whistleblower disclosures. The number of prohibited personnel practice cases has risen by about 10% in the last year. So there at least is there's a lot of feeling out there that much needs to be improved and corrected, and people are coming forward with that information. And whether they come to us or they go to the media, there's a lot out there to be addressed.
One asterisk I want to make sure that we drop at what Matt and Lucy and Tom said. I know the one case that we all know about in which there was a subpoena, and that's being played out publicly. There are other cases. I think Mike Isikoff did an article, and I think others did an article on how the government is getting cell phone records and email records. Here's the asterisk. The Justice Department's reticence to send a subpoena to ABC, NBC, CBS, whatever, CNN, MSNBC, for a piece of information may be at the same threshold. Interestingly, Tom, the flower pot, when you're using your Yahoo account, your AOL account, and you're the same guy, you're the same reporter operating under the First Amendment, guess what? That's not deemed necessarily to trigger that media requirement in the CFR. And there are all kinds of acquisitions of information. When you think you're dealing in your private self, you're never a private self. And that's just the asterisk. You'll see other cases in which this information is being gotten by government agencies from journalists, but it's not from their at whatever it is, journalism.com, org, or whatever. That's something to be careful about, right?
Absolutely. And I had one fellow from an intelligence agency tell me a few months ago, you know, that rise in subpoena, that's probably the last one you're going to see from us, because guess what? We don't need you anymore.
Right.
There are ways we can do it without, you know, wasting our time with your lawyers.
And it's that's a difference. And that's either
It's
a difference
huge.
of tactic or a difference of technology or the combination of both. Gary, is there, in going back to something you said before, and I want Gary and I guess Tom to do this one, is there, in your perception, because of the financial incentives, if nothing else, a greater amount of whistleblowing occurring out of private companies? And if that's the case, do you find that the agency, whether in SEC is not a bad example, are overtly or not overtly working with their companies to prevent the flow of that kind of information that expose what they've done and not done?
Definitely. Let me say, first of all, that since Dodd-Frank became law on July 22nd, 2010, there has not been a single whistleblower award by the SEC. Not one. Not one. There's talk about tens of millions of dollars that are going to be paid in whistleblower awards. There have been none. So the issue, as far as I can see right now, is this has been, it was supposed to be an explosion. You could barely hear the bang. No one is, you know, I mean, the lawyers that are handling whistleblower cases, and there are quite a few of them. I've submitted some of the cases to the SEC myself, and what I'm finding is that those cases are outsourced back to the companies. The companies hire large law firms. Those large law firms conduct the investigation, and guess what? They don't find any violations. They go back, they present it. I have internal FBI reports that show how one large law firm went to the FBI and the SEC, and basically both the FBI and the SEC conducted no investigation other than listening to one of the largest law firms in the world go through a litany of the facts that sounded like a defense lawyer making a closing argument.
That's the second time you'd mentioned that, so hold on. Later on, will you tell me the number I called to sign up for that, getting to work for large firms? I'm just making a note. I'll put that away later. Tell me the dialogue. What's the mechanism by which an agency is actually working with, and you may have said it, by hiring their own private counsel. Why is it that if that happens, an agency asks the company to investigate itself? And
yes.
Assuming that lawyers, notwithstanding our reputation to the contrary, are supposed to be officers of the court and find what we're supposed to find, what is it that prevents that from exposing more wrongdoing by way of voluntary disclosure programs, et cetera. I'm not sure if everybody's following why it would be, if an agency triggers an internal investigation, that is a way of stifling whistleblowing.
Well, if you are a whistleblower inside of a financial institution and you are at risk, and for example, let's say you're inside of a large hedge fund and you've concluded that there was insider trading going on some few million shares of XYZ. You go to the SEC, you report that violation. The SEC goes back to the hedge fund and says, hey, you know, we've got this report on that so-and-so was trading in XYZ on non-public information. Well, how long is it going to take the hedge fund to figure out who disclosed that information? And when they figure it out, it's going to be, you know, an execution for that whistleblower. So a whistleblower can foresee this and appreciate the fact that it's career suicide to communicate that information to the SEC. And if you add to that fact that the SEC is making no awards, there's no incentive. So that Mark, it's been killed. Dodd-Frank whistleblowing is a dead issue.
So Tom, let me ask, and then Mark. So look, Matt spoke as the spokesperson for the Department of Justice, and today spoke as to the inherent importance of whistleblowing to our democracy. We have statutes that make it both financially and incentive, and there's protections. Except every time that you read about a whistleblower, whether it's Drake or if that's one that we'd agree is a national security whistleblower, or the FDA scientists, or the folks at the Dover base, or the guy at the Department of Interior, notwithstanding our hurrahs, there's always the allegation of retaliation. They're always either sued or charged or demoted, and I say always, but I'm making the point. It seems that they're always that. So if that's the case, where's that? Why is there a disconnect between us all sitting on the stage with the lofty pronouncements that it's good to whistleblow, and then whenever there's an actual case of whistleblowing, there's an allegation of retaliation? What do you think, Tom?
You know, I can't answer why there's retaliation. I mean, I'm not a lawyer. You get plenty of lawyers up here to answer that question. If I'm working in an agency and someone's a whistleblower and then you try to fire that person, and again, I'm not a lawyer, I would think almost everyone in that agency is saying, you're going to do what? You're going to fire this guy? We saw that with the Office of Special Counsel and the Dover mortuary. What happened when they fired that guy in particular? They've just released a report today about that issue. They sent it back to the Air Force for further review. I'm not sure what's going to happen to those supervisors, but, you know, it's a serious issue with those guys.
Mark, what I mean, it is, there's this phenomenon, and why is that? Go ahead.
It's a question of power, ultimately. And that
is it knee-jerk, though? Is it that, notwithstanding, on one side, we will pronounce that we like it, but when it's our agency and me being called the jerk, I can't help myself?
I think it's a reflex. You know, having been in management situations and people challenge you, you immediately feel attacked. I mean, it's just, I think it's a human reaction that people have when they're in positions of authority and people challenge their authority. And that's why the protections need to be in place, because otherwise those who have the power can impose their will.
You know, Lucy, it seems like, just like we always say, that it's never the offense, it's the cover-up when there's a crime. It seems like it's never the actual thing that's being blown about, but it's the retaliation that then gets to show how significant it was.
You know, I think the cases where the whistleblowers probably come out the best in the end are the ones where they blew the whistle and there's a few months of hell. The Arlington cemetery situation comes to mind. The Dover mortuary stuff. If you do something having to do with veterans, you can somehow cover it up for a while. You can retaliate. There was a young woman who was working in PR for Arlington Cemetery who tried to handle that whole thing fairly well. She was retaliated against almost immediately. But after a certain period of time, when they figured out just how bad it was and the heads rolled down there in the office, all of a sudden people said, oh, wait a minute, she was right, that was unfair, and I think she's going to be okay now. But if you mess with, the best cases I can think of lately have something to do with the military, the veterans, whether it be Walter Reed or Arlington Cemetery or Dover. You hit a nerve on something like that, and the public's just not going to put up with it. But you do something, dealing with the SEC, where only 1/10 of 1% of America even understands what those people do. It's going to be really, really hard to translate that in terms the public can understand.
So, I mean, is it possible that therefore, the only safe whistleblower is one who's pointing out something bad that we're doing for our troops and veterans?
Or other
unless you
people
cross
like
the
that.
line of it being a national security classified, or everybody else is at their peril, Gary's story not being an insignificant one. Is that where it's at?
Well, if you can figure out, another case where I hope these folks are going to be okay, are the ATF agents who blew the whistle on Fast and Furious.
Fast and Furious is good. Yeah.
And
we don't know the end of that story yet, right?
We don't know the end of that story. So far, it looks like the folks that had the whistle blown on them might have actually, a couple of them have been promoted, and there appears to be some retaliation going on against that. 6 or 8 agents that were involved in all of that. Hopefully, they're going to come out okay, because the public reaction to that story has been monumental as well.
Let me take some questions from everybody else here, and I'll have that as my last question, a follow-up on this for each of you to comment. So think about what your answer will be, and I bet it will be different, as to how can you be a whistleblower in today's world and not commit professional suicide. But that will be my last question. My next question will be from somebody out here, all the way in the back with your hand up. I don't know if there's going to be a mic. Is there going to be a mic? Or everybody should come to a microphone and line up? All right, hold on. So how do I do this? Should they shout, or what should we do? You should shout, and I'll repeat the question. Well, speak loudly.
No problem. I'm Kathleen McClellan from the Government Accountability Project, and my question is for you. Mr. Miller, you mentioned John Kiriakou's case and a lot of, some of the charges against him. That's interesting, and, there's also been a lot of talk about Tom Drake, and we seem to all agree that he's a whistleblower. But a year ago, this is what the Justice Department said about Tom Drake in a hearing, that it's not an issue of benign documents, and the NSA collects intelligence for the soldiers in the field, so when individuals go out and they harm that ability, our intelligence goes dark and our soldier in the field gets harmed. That was what the Justice Department was saying about Tom Drake a year ago. Why is it different now? Is it because they lost?
I think the Drake case is the classic example of the tension that exists, where you can both be a whistleblower and violate the law by telling the press about something that's classified. Both things can be true, and I think both probably were true in that case. I believe when Justice brought that case, I don't believe their intention was to classify a whistleblower. I know the people that signed off on the case; they thought they were prosecuting someone who had violated the law. But I think what that case reveals is that there are checks and balances in this system. They're built in throughout the system to prevent people from going to jail who did the right thing. You can take it one step, you can back it up one step and look at someone like Thomas Tam, who blew the whistle on the warrantless wiretapping program, admitted to it on the cover of Newsweek, but has never been prosecuted, largely because it's quite obvious he blew the whistle on something that was illegal. Drake, while he was prosecuted, at the end of the day, that case collapsed, and it collapsed. I think largely because there's still some things that happened in that case that are under seal, but some of the judge's ruling in that case were because he just didn't buy that Drake was not a whistleblower.
We need to. I'm sorry. I just want to make sure a number of people get their chance. So please go ahead.
On page A15 of this morning's New York Times is a story about Democratic senators, complaining about broadened or expanded powers that the government has taken under the Patriot Act, which are these are powers which are not public. And they said the public would be stunned, I think that's the quote, if we knew what the government was doing. Since you've touched on technologies and prosecutions, wonder if you could try to imagine what kinds of powers these might be that we don't know about.
Lucy, are you a good person to opine?
I imagine, my guess is that we are all under intense electronic surveillance of various types and that they are just basically scraping everything we do at all times.
The ability to scrape, again, I just want to point out, the ability to scrape from things that we think are benign, which is the way we communicate via emails at various service providers, et cetera. I mean, it makes it a lot easier. It might be. I don't know if anybody knows what they were talking about, but I would imagine that would be it. Yes, go ahead.
Nate Jones from the National Security Archive. Does the American media pay too much deference to national security claims, breaking the law, as opposed to other leakers, even if they're valid? For example, the Taguba report, if that was kept secret, probably would have advanced American national security. And then going further, what about foreign media that aren't Americans, and what about non-state media? And that's to anyone.
Hey, well, why don't we start with Tom?
You know, I'm not sure what impact it would have had if it were kept under wraps. We had the pictures of Abu Ghraib come out and, you know, splashed all over TV and blogs and so forth. So I'm not sure if they would have been in better shape having the Taguba report kept under wraps. It just gave us, it put it all in context. What happened to this place? You know, who dropped the ball with regard to the Abu Ghraib prison? So I think it was important for us who write about this, and it was important for the American people, I think, to find out exactly what happened here, who was responsible. And it went all the way up the chain of command to General Sanchez at that point.
It's not as if the news media changes the criteria of what's particularly worthy of getting into the front page in a whistleblowing situation than they would as to any other source of information, right? I mean, the story that has NSA in it or national security or something like that is going to create a bigger splash than, except for in Washington, where everybody reveres the Redskins, about trees next to a person's mansion. So that doesn't surprise me that, you know, to answer your question, it's almost an obvious, which is the media is very interested when it has the phrase national security in it, perhaps because we're all interested in it as well. So next question, please.
Hi, my name is Tracy Eaton. I'm a freelance journalist. I'm wondering if anyone on the panel has an opinion on transparency and accountability at USAID. As you probably know, an American, Alan Gross, is in prison in Cuba after taking part in a democracy program that was financed by USAID. Thank you.
You mean in that agency particularly having it? I don't know if anybody has a particular. Do you, Mark? I don't know. Matt, do you have any view?
No, I don't.
I don't know. Gary, are you familiar with USAID's? I don't know if it's better, worse, different. I mean, if you're suggesting that there was more to what Alan Gross was doing in Cuba that the agency hasn't disclosed that would justify why it is that the government of Cuba has kept him for so long, if that's sort of the import, I don't know that anybody here would know that that was the case. But what we do know is that there's not been a whistleblower that says so yet. Go ahead.
My name is Tom Devine. I'm with the Government Accountability Project. This question is for Mr. Miller. Why are you saying that Tom Drake disclosed classified information when he was neither charged nor found to have disclosed classified information? What is your basis, if any, sir?
It's a fair point. While he wasn't charged with leaking classified information, the government charged him with mishandling classified information, with retaining classified information that he shouldn't have. Charge him with that, I believe, frankly, because that's they thought would be an easier charge to prove in court. But he was not technically charged with the leak.
I'm sorry.
No.
I was just going to add that the allegations in that indictment, had it gone to trial, would have included evidence probably of the disclosure. But the charge was about the handling, because as Matt pointed out, there was material found in his possession. It's a lot easier than going through the rigmarole of who was the source, whether it was national defense information, whether it was closely held, et cetera, et cetera.
And honestly, one of the reasons you charge a case that way versus a leak is to avoid a media subpoena.
Yeah, absolutely. Let me round up before I go. If there's a last question here, it's just so everybody does it. Hey, Gary, speaking of Gary, can a person figure out a way to be a whistleblower today without committing professional suicide?
It's tricky. I think that there are channels, what I consider safe channels, and you have to walk down those corridors. If you step off the corridor, you can be in trouble. My own, and you don't even have to step off the corridor to be in trouble. In my own situation, the SEC subpoenaed my communications with Congress threatened me with criminal prosecution for going to the Office of Special Counsel. So it's risky, but you've got to make sure you stay on those protected corridors.
Mark, does OSC need more tools or more staff, or maybe that's the unfair question, asking somebody whether they need more staff. Is it working about right in terms of...
Should I say no?
you should say the truth. We're in the museum.
Yeah. Well, I would be committing professional suicide if I were to say that there weren't anything that we could do on behalf of whistleblowers. But it's never going to be an easy road to hoe, and the dangers are very real. Many of the people in this room, Tom just spoke, Kathleen, Danielle's here, many people here are working tirelessly on behalf of whistleblowers. And I think have great effect in terms of protecting them, and not just in the cases of veterans, but across the board. And I believe as well that OSC is and will be more effective at that in the future as well.
Lucy and Tom, it's clear from what Gary said, what Mark said, what we've talked about with Matt in terms of some of the individual cases, the individual whistleblower is not at less risk, certainly feels like he or she is at equal or more risk to be a whistleblower. Do you and does the media feel like journalists, members of the media, are at more risk when they're now dealing with whistleblowers than they were 10 years ago?
You know, I don't feel that in my own job. And also, you're not necessarily committing professional suicide by dealing with a reporter. We're looking for the information. Is it compelling and is it true? It could be a report that's been through many hands that could find its way to my desk. I don't necessarily need his name or anyone else's name. I just need that information.
Please.
I'm not worried. Most of the editors and folks that I talk to are not so much worried about the national security or other whistleblowers as far as being subpoenaed to a criminal case where it's actually, and we don't have time to talk about this, where you have more expensive exposure is when you are interviewing a public employee who has somehow given you information about another person, and they bring a Privacy Act lawsuit. Oh. And you are subpoenaed as a third party to identify which government employee leaked information about another government employee. Yeah. That's an incredibly expensive endeavor to fight those off.
As Lucy just pointed out, those things that we've just raised and only touched the surface on could be its own program. That's one of the nice things about the fact that FOIA Day recurs every year. I remember last year we were here and we were discussing some of these topics with a different slant. Somebody's already pointed out what the status of the Drake case was it then. Many of the things we talked about today were not cases then. So it does look like there'll always be fodder for this. With that, please thank the panelists and Patrice, I'll take it to the next one.
I want to thank Abby and all of the panelists for a terrific discussion. And yes, your release. So we're going to start getting our next group of panelists up here, and I'm hoping everybody is here. And as they're coming up, I'm going to introduce them again alphabetically. Alexander Abdo is a staff attorney in the ACLU's National Security Project. He has litigated cases concerning the Patriot Act, the International Emergency Economic Powers Act, and the treatment of detainees at Guantanamo Bay, Afghanistan, Iraq, and the Navy brig in South Carolina. Danielle Bryan has been the executive director of the Project on Government Oversight since 1993. She was inducted into the Freedom of Information Act Hall of Fame in 2006. Ms. Bryan also serves as the chair of the steering committee of OpenTheGovernment.org. Elizabeth Goitein co-directs the Brennan Center for Justice, Liberty, and National Security program, which seeks to advance effective national security policies that respect the rule of law and constitutional values, including the values of transparency and accountability. Bill Leonard, they're getting their mics. Some confusion. Bill Leonard is a retired civil servant with 34 years of federal service, including as the director of the Information Security Oversight Office, otherwise known as ISOO, and as a Deputy Assistant Secretary of Defense. Dana Priest. Is Dana here? Not yet. Well, hoping she shows up. She's a 2-time Pulitzer Prize winner at the Washington Post and the author of the best-selling book, Top Secret America, The Rise of the National Security State, which built from a series that she did in the Washington Post that went on for several days. And Jeff Smith is the head of Arnold and Porter's National Security Practice. He has served in the Pentagon, the State Department, and the Senate, where he was General Counsel of the Senate Armed Services Committee under Sam Nunn, and as General Counsel of the CIA in the Clinton administration. He has advised media organizations, universities, and individuals on issues associated with classified information and the First Amendment. We're trying to move ahead quickly so that we have time for questions, and there's an excellent panel that follows us after a brief break. So with no further ado.
I can do a song and dance while they're getting
okay.
set up.
Thank you.
I realized we really are the most nerdy of groups, that while there's the March Madness going on, here we are talking about open government. While my panelists are getting set up, I actually wanted to reference a couple of things from the last panel that I thought were really fascinating. One is Mark didn't give credit to, I think, one of the important things that's happened with the Office of Special Counsel, and a good reason why they're maybe getting a lot more disclosures, is that there's a lot more belief that that agency is actually functioning and doing well with the new leadership. So our experience at POGO is, in fact, if anything, there is maybe a decline, at least in the world of national security whistleblowing. So it was sort of surprising to hear the theory, of course, maybe in the SEC world because of Dodd-Frank. But in general, I think the suggestion that there's an increase in people blowing the whistle, at least in national security, has certainly not been our experience. So I guess we'll go ahead and hope Dana joins us. Fabulous. Okay. So while she's getting set up, I wanted to start this panel, and I'm going to quickly sit down because this is a fantastic group of people, and I just want to sit with them and listen to what they have to say. I read two perspectives on the Obama administration and that collision between national security and open government, and I just wanted to share them with all of you because they're very different approaches to this issue. One was what Gary Wills wrote in the New York Review of Books a couple of years ago. The way he saw it, he said, "A president is greatly pressured to keep all the empire's secrets. He feels he must avoid embarrassing the hordes of agents, military personnel, and diplomatic instruments whose loyalty he must command. Keeping up morale in this vast, shady enterprise is something impressed on him by all manner of commitments. He becomes the prisoner of his own power. As President Truman could not use the bomb, a modern president cannot not use the huge powers at his disposal. It has all been given him as the legacy of bomb power. He is a self-entangling giant." So from that perspective, it's almost an impossible situation, and we can't do anything about this tension. On the other hand, Josh Gerstein had a fabulous article in Politico last week where he hearkened back to one of my favorite Huffington Posts to go crazy over that Beth Novak wrote last year, where he said, "In retrospect, open government was a bad choice." Beth Novak wrote. She was the head of the Obama Open Government Initiative from his inauguration to last year. She went on to say, "It's generated too much confusion, this term open government. Many people, even in the White House, still assume that open government means transparency about government." She went on and explained to him in an interview that some open government advocates have put too much emphasis on the Freedom of Information Act and revealing national security secrets. So from her perspective, she said, "This is a whole paradigm shift in the way that government gets information, makes decisions, and implements those decisions, and not simply a rehash of a debate about national security, a debate in which we just go in circles with the same old players," which I think I may be one of those same old players, "and the same old arguments." So could it be maybe that this panel, and the subject of this panel, isn't as important as I think it is? Or is it an impossible situation, or is this really a false situation, as Beth Novak suggests? And I'm hoping by the end of the hour that if this is a problem, the tension between national security and open government, that we will have identified some solutions by these brilliant people. So I'm going to sit down. And is this working? Can you still hear? Can you still hear? Okay. So one of the first things that I wanted to ask this panel is, let's assume there are some, let's start from the beginning. Are there some legitimate secrets? And what are they? Can we identify what they are, and who should be able to keep them? I want to ask Jeff that question first, as the former CIA General Counsel.
It's both an easy question and a hard question. The easy question is, of course, there are secrets. If you think it was appropriate for us to target Osama bin Laden, we could not have done so without secrecy. On the other hand, there are clearly instances in which the government misuses secrecy. Some of you have heard me talk about this before. Secrecy can be very corrosive. It's very seductive. It's a way of protecting what the government does for legitimate purposes, but it's easy to have it expand too much and protect things that aren't secret because of convenience and a variety of issues, a variety of motivations that aren't good. And the challenge, frankly, for the press and those of us who care about these issues is to keep probing and keep asking those hard questions. And sometimes the government squeals that things have appeared in the press that are secret and do harm, and that is true. On the other hand, the responsible press, in my experience, and Dana being one of the very best, understands that and works very hard to figure out where that line is. But it's in a democracy, it's one of our most important questions. And the role of those of us who work in this area and care about both freedom and what we have to do to stay safe, there's no really easy answer here. But each of us have to do our job, and those of us who are in the secret world, we have to make sure that we don't overclassify things, and Bill can talk about that with great care. And those of us in the press have to keep pressing to try to find those secrets and expose things where things go wrong.
Well, let's ask Dana. You are both, as a journalist who is also covering exactly this issue, you had a groundbreaking series and a fabulous book on the subject. What's your sense of this question?
Well, my sense is that it will always be a contest between the government's right to keep secrets, and there are secrets that should be kept, and the press's duty and responsibility to probe government and reveal things that sometimes are secrets but will not damage national security but are of great national interest. This contest will never be solved. It should never be solved because the way the Constitution's laid out, to solve it means you either take away some of my right or you open up all the secrets, which neither one of which is realistic. So if it is a contest, then you look at both sides and say, are they playing fair, I guess is what you could say. And I can play fair only by, when I discover secrets, to speak with the government about it and hear their side of why we shouldn't publish things, and try my best, and the decision's not mine, it's the head of the Washington Post, but to make an informed decision about not publishing things that are truly going to damage national security. On the other side, and this is where I'd like to focus more, because on the other side, it's a falsehood to say that all secrets really need to be kept, because so much, not only overclassification, but just the habit of classifying things and the habit of not speaking honestly with the American people about some things you can speak honestly with them about without damaging national security. I think a lot of us thought, because when the candidate Obama was wanting to be president, promised more transparency, and that has failed tremendously. So there's great disappointment there. It only makes the journalists work harder to thwart that. So I don't agree with the sentiments that we misinterpreted it. I think we see it correct in saying that this administration is not open. It's in some ways less open than the second term of the Bush administration. And instead of berating the press and trying to intimidate us through public media, through the media, which the Bush administration did, they're using the courts to do the same thing, and in some regards, that's much more serious.
Let's explore that question. That's really fascinating. So we have some litigators at the other end. If you wanted to talk about this question of, is it your experience over the ACLU, is this actually less transparent than previous administrations?
I think that's a difficult question to answer. In part, the Obama administration started out on a good foot. They released memos that the previous administration had kept secret without due cause, and they committed themselves to a transparency. But over time, some of the arguments that the administration has made in court have, in fact, entrenched secrecy in a way that not even the Bush administration attempted. And I'll give you a very concrete example. During the Bush administration, we sought photographs, additional photographs similar to the Abu Ghraib photographs from other facilities throughout Afghanistan and Iraq. And the Bush administration argued that they were exempt from the requirements of the transparency laws because they would serve as propaganda for our enemies. But the Bush administration never made the argument that the Obama administration now makes, which is that textual descriptions of similar misconduct can also serve as propaganda to our enemies. And for that reason, the Obama administration has withheld additional reports of the inspectors general about abuses committed during the Bush administration. It continues to withhold those same photographs and other things. So it's a bit of a mixed bag, but I want to go back to one of the first points that Dan was talking about and that you were talking about, Danielle, which is the secrecy protect itself? And it is indeed seductive in the way that Jeff suggested, and it's particularly seductive to the political branches. And I think for that reason it's critical that secrecy not be something left solely to the political branches, that there be a system of checks and balances to ensure that there's independent oversight of decisions to classify information. And since 9/11, the courts have, by and large, refused to play that role when it comes to most of the extraordinarily important information that has been withheld as classified. And part of that is a problem with the way that FOIA is written, and part of that is a problem with the way that the executive represents security threats to the courts. It's a difficult problem to solve, but I think it's a critical one that we think about in addressing transparency in the national security realm going forward.
I can't let that statement go without asking, is there a quick way you could say what the fix to FOIA from your perspective would be? Because I'm such a wonk. Quickly, could you do that?
I can't give you a statutory fix, but I think that the quick fix would be that courts need to engage in a more substantive review of classification decisions decided by the government. Courts now think their only role is to look at classified declarations submitted behind closed doors to make sure that they make sense in some broad and vague way, and then to rubber stamp them. And I think courts need to do more than that. So, for example, the gentleman during the last panel who was referring to a secret interpretation of the Patriot Act that comes in our FOIA lawsuit, and it relates to a secret interpretation that the government has of Section 215 of the Patriot Act, one that Senators Wyden and Udall have decried as divergent from what the public would think the law means. It's difficult to understand what the possible basis could be for keeping secret a legal interpretation that wouldn't reveal, properly kept secret sources and methods. But nonetheless, the government has argued that that legal interpretation should be kept secret.
Liza and Bill, you both have great things, I know, to talk about on this question of the OLC memos and what the courts are doing now.
Sure. Well, just to add one point about the courts and how they treat FOIA requests that involve classified information, if a member of the public seeks the declassification of a document through an internal agency process known as mandatory declassification review, more than 90% of the time, the agency finds that some or all of the document can be released. If a member of the public brings the same challenge in a court through FOIA, the judges almost routinely uphold the classification. And we know that the MDR process, the agency internal process, that they are not erring on the side of release. So, I mean, this pretty much proves that judges are being overly deferential when it comes to judging the proper classification of information. And on the secret law point, I would add another thing, which is that this secret interpretation of the Patriot Act, it's not only that the interpretation is counter to what the statute says or would intuitively be interpreted to mean. Apparently, the administration has also been making public pronouncements about its interpretation that are inconsistent with this interpretation. So part of the problem with having any kind of secret law is that there's an element of deception when there's one set of laws that are on the books and another set of laws that are different, that are secret. And there are a number of different contexts in which that can arise. OLC opinions is one, secret FISA court opinions is another.
And just to add to that, I mean, I for one find it phenomenal that, you know, every day we're inundated with these tremendous debates from a political point of view in terms of what's the proper role of the central government, how much authority should the central government has. And it centers around things like mandatory health insurance and teaching levels for the third graders and regulation of carcinogens and things along those lines. There is absolutely no debate whatsoever that occurs in terms of under what circumstances should our government have the right to intercept our personal phone calls and our emails and what have you. There is no public debate with respect under what circumstances can our government kill anyone in this room by an extrajudicial manner. And the fact that over the past 10 years, we've seen this tremendous accretion of powers unto the executive that is not even talked about. Not only is it not even talked about, but, you know, in terms of OLC memorandums, the one that was used supposedly as the justification for the killing of al-Awlaki, we will not even get an official confirmation that such a legal opinion exists. And so it just strikes me as very corrosive to the very form of government that we have, that these things are happening outside of the debate in the public square, outside of the debate in the halls of Congress, outside any sort of judicial review, with absolutely no opportunity for the two co-equal branches of government to weigh in.
You have suggested that there might be a trend that's a glimmer of hope in the courts, however?
Well, to build upon the comments here, I think it's very useful that we are seeing, in some instances, situations where the courts are getting involved in the substantive issue of information that's being withheld ostensibly for national security reasons. For those of you who follow Steve Aftergood's blog, he gives prominent reference to the FOIA case involving the U.S. Trade Representative, where the judge, in fact, has ordered the release of a document that is ostensibly classified. I personally has been involved in two cases as an expert defense consultant and potential defense witness involving the Espionage Act, and the one case known as the APAC case, the other involving what was discussed earlier, the Thomas Drake case. And in both of those cases, I was very pleased to see that the judge was not willing to allow the executive to do what they normally do, and that is to waltz in and to simply assert that this information is damaging to national security and the story. And so I was very encouraged by that. And just to give one example, one more example, several years ago, there was a state secrets case involving the Horn case, where it involved ultimately involved the identity, withholding the identity, dismissing a suit because withholding the identity of a former CIA intelligence officer. Unfortunately, years before the court ruled to include the appeals court, the CIA had rolled back, that is, declassified that identity of the CIA case, and the judge in that case rightfully said that the executive committed a fraud against the court by coming in and simply asserting that this man's identity required protection in the interest of national security. So we're seeing it. We're seeing glimmers of it, but I agree that ultimately is one part of the solution, is to get the two co-equal branches of government to get involved from a substantive point of view.
Knowing, as a student of government, that there's actually 3 branches of government, I'd love to go back to Liza and ask the question on the Congress, and what role are they playing or not playing in their duties to conduct oversight?
Well, I mean, part of the issue is what information Congress can get from the executive, and that's a huge issue. You know, the executive branch is statutorily required to keep the intelligence committees currently and fully informed about intelligence activities, both existing and anticipated. But as a practical matter, there are several caveats to that. First of all, the executive branch can brief only a smaller gang of 8 on covert operations, which it tends to interpret quite broadly. And whether it's reporting to the covert operations or other operations, there's a lot of wiggle language in the statute, you know, to the extent is consistent with the protection of this and that. And sometimes the executive branch just doesn't give the information. You know, an example is the CIA assassination program that was in the works for something like 8 years that we found out in 2009. Congress had never been briefed about it. And then I guess the final caveat is that, you know, if the executive branch does give information about its activities, classified information, to 8 members of Congress or to the members of a committee, I mean, what can those members really do with that information if they can't share it with the rest of Congress? I mean, they can't pass legislation on their own. And the executive branch takes the position that members of Congress who have been read into a classified program cannot share that information necessarily with other members of Congress. And, you know, that doesn't leave them powerless, but it certainly ties 1 or 2 hands behind their back in terms of meaningful oversight.
Although I find it unbelievably outrageous that the Congress allows the executive branch to tell them what they can and can't do in this regard. But I know Jeff had something he wants to add on this question.
My sense of the current administration in terms of briefing the intelligence committees in particular is markedly different than the previous administration. And I think the worst example of which I know is the previous administration's reluctance to let, other than the so-called Gang of 4, know anything about what later became, depending on your characterization, either the NSA warrantless surveillance program or the terrorist surveillance program. And you'll recall that they wouldn't let, as you quite say, Lisa is quite correct, they would not let the leaders of the 2 intelligence committees bring in their staffs. And Senator Rockefeller, who was the chairman and then the vice chairman of the committee, was so upset about this that he wrote a letter, a personal letter, handwritten letter to the president, saying, I do not understand what I am being told. They are telling me that there are these algorithms that would permit that will protect American liberties and so on and so forth. But frankly, I'm not a mathematician. I don't understand this. I want to bring others into it, including the staff. He never got an answer to his letter. Now, the current administration has been much better about that. That's in part in nature of, I think, the personalities involved. But I think it's also a recognition that it's a huge mistake politically not to have the Congress with you. So that may change over time, but I do not wish to sound political, but I do think the current administration is doing much better for a variety of reasons. Panetta was a creature of the habit, a creature of the Congress, and Director Petraeus and General Clapper take the same view. So I think we're doing a little better on that front. One interesting footnote, I was General Counsel of the Senate Armed Services Committee for a while, and I was always struck with the irony that our very most secret operations that are intelligence operations are briefed in excruciating detail. You may not believe this, but it's true. Excruciating detail to the 2 intelligence committees. Operations conducted by the Department of Defense under Title 50, nothing. Congress doesn't know anything about that. All the special access programs, all the black stuff that DOD is doing, if Congress finds out about it, it may be by happenstance, it may be because they've really drilled down, but the President can move military units all over the place and doesn't have to tell Congress anything. CIA sends 3 people into Ruritania with a secret copying machine, and we have to tell the Congress. So I've always thought an imbalance, and I'm glad to see Dan agrees with me, an imbalance between what we call Title 10, which is DOD, and Title 50, which is CIA. It's an accident of history But I think one of the fruitful areas, frankly, for congressional oversight would be more into the military operations than into the intelligence, and continue to press on intelligence. I'm very much in favor of vigorous congressional oversight, but I think a lot more could be done on the Department of Defense Title 10 side.
Well, I just wanted to add two things. One on the Title 10, Title 50 discussion is the most relevant topic in that is this the operations by the Joint Special Operations Command, JSOC, which the SEAL Team 6 is a part of. So because they operate under Title 50, they don't need to brief the defense committees, even though what they do looks an awful lot like covert action. I think this administration has taken a somewhat different tact, and they have begun to brief the defense committees on certain activities of JSOC, but that was not the case during the Bush administration. The second point is, I think that in the three legs of the stool that hold these intelligence secrets secret, the legislative part is the weakest one, and it's the thing that you could one could probably do something about, because members have expressed a lot of frustration, not only not knowing their rights, but also really not being confident enough to push the agencies to give them information. So how do they get more confident? Well, Senator Graham, who was the chairman of the committee at one point, he had started at Harvard University a sort of class for the incoming committee members to take, because it's unlike any other realm. You can't ask an outsider really to brief you on a secret, but you can ask, if you're a member of any other committee, you can do that, but you can't really in this regard. So to have some sort of, here are your rights, here are your responsibilities, this is what this means, this is what that means, I think would go a long way to at least empowering Congress to act like it should.
Liza? Just a couple of quick things in response to what Jess said. It may very well be true that this administration is voluntarily sharing more with the intelligence committees, but when there was legislation that would have sort of done away with the Gang of Eight and required the president to keep the full committees informed, he threatened to veto it.
Oh, that's true.
And then the other point that I wanted to raise is that I just want to be careful that we don't look at, I agree that congressional oversight is probably the weakest piece, but I think it's also not a panacea. If we could wave our wand tomorrow and have Congress get all the information it needed, you still have the problem that, these are elected representatives. They care about what their constituents and their donors care about. If their constituents and their donors are in the dark about certain information, such that the members are not getting angry phone calls and angry emails, they're not really institutionally incentivized to care. So it's not that I don't think informing Congress is important. It absolutely is. I think it's necessary. I'm not sure it's sufficient. The secrecy that I'm concerned about is not just the secrecy vis-a-vis Congress, but very much secrecy vis-a-vis the public, who needs to get involved in a lot of these.
Jeff wanted to add something.
Very brief. I agree with that, Lisa. I think that the motivation for members of Congress in the intelligence committees is very different than it is in many of the other committees. There's almost no political benefit to serve on the intelligence committees. You can only get in, this is a vast overstatement, many members of Congress think it's fascinating, but you can only get in trouble by serving on those committees. Because if something goes wrong and you didn't know about it, you're at fault, and they'll tell you all these secrets and you can't do anything with them. And yet, in many ways, they do serve as a break. I can remember very clearly one episode many years ago now where the administration had come up with a completely wacky idea for a covert action, and it was when I was in the State Department. We went up and briefed the Senate Intelligence Committee, and Senator Scoop Jackson was on the committee. It took him about 10 minutes to completely decimate this idea. And we all trooped back down the hill, and it didn't happen. Now, had that not been required to have been reported to the committee, the United States would have done something very dumb. And that's oversight that works.
Before we leave the question of the Congress, I find it fascinating to see how far back we've rolled in terms of Congress's sense of self and rights to the information. That Mickey Edwards, who's a former Republican in the leadership during the Gingrich Congress, has been very articulate on this question of why is it that someone, often not even a sort of a mid-level person at an agency, deciding who is allowed to brief him or be involved in his briefings, but it's often a contractor who's deciding who has clearance to hear these things. Now contractors are typically doing the security clearance reviews. But back when you look during when Jack Brooks was chairman, he was outraged that anyone in the executive branch, either federal employee or contractor, was deciding who on his staff could have a clearance, and he demanded that the Capitol Hill police were the ones that did the security reviews for his staff. So the idea that now the Congress acts or accepts that the executive branch is just telling them what they're allowed to do and who on their staff can do it is it's certainly been in my professional life. It's relatively recent. One thing that we skipped over a little bit that I'd love to explore a little bit more is the cost of secrecy. I know, I forget if it was Bill, or it was Jeff who talked about the corrosive effects, but if we could explore that a little bit more, I'd love if we could have some sort of sense of the financial cost. I know, Danny, some of your reporting has talked about that, but the ideas of what is the impact of excessive secrecy?
Well, apart from the cost, my major concern with excessive secrecy is it makes for bad government. It makes for faulty decisions. Obviously, no matter what you're talking about, the more opportunity you have for give and take, consideration of alternative ideas, approaches, other viewpoints, things along those lines, you're going to optimize the outcome. You're going to optimize the decision. And the problem is when you apply secrecy to the decision-making process, right off the bat, you're agreeing that I'm going to accept something less than the optimal outcome. And that may be worth it in terms of the trade-off, in terms of whether you're protecting military operations or intelligence and what have you. But the problem is that, from my perspective, that debate never occurs, and it's almost reflexive. And so, if you look back at some of the most tragic policy decisions that have been made in the past 10 years, ranging from the decision to go to war in Iraq over non-existent weapons of mass destruction, and the decision to include FEMA in the Department of Homeland Security when it was first stood up. Those are just two prime examples of decisions that were shrouded in secrecy, turned out to be totally abysmal decisions, and Americans have paid for in treasure and blood as a consequence of those decisions. So without a doubt, that is, I think, the most corrosive cost of secrecy, and dictates that, especially when you're dealing with questions of going to war and questions along those lines, the greater openness, the greater sense of debate, you're going to just get that better of a decision out of it.
Just to add to that a little bit, so I wrote a book on this subject called Top Secret America that really was meant to say, what has grown up since 9/11 to deal with counterterrorism, how big has it gotten, and then so what that it's gotten big? Well, it's gotten huge, and we document that in a lot of different ways, but the so what, one of the big answers to that is that even when you have put in place a lot of information sharing mechanisms that did not happen before 9/11, and the government has put a lot of those in place, just by the fact that it's grown so big, it tends to mitigate that or cancel that out in some ways. And some of the people that were willing to help me do the reporting for this were people that were so frustrated by this. They were so frustrated that, they were in the middle of military operations but couldn't know things that they knew were important to know for those military operations. And my favorite quote from the whole thing is Jim Clapper, who's now the DNI, but at the time was head of intelligence for the Department of Defense. We were talking about special access programs, which are even more highly classified than top secret, and you know, the fact that nobody had a handle on what all of them were in the government, so that you could cut down duplication and make sure that people who needed to know. And he said, really, the only person that knows all the saps, they call them, is God. And
he ain't talking.
And it was just a fact of life. So,
Alex and Liza both want to.
I agree with both what Bill and Dana said, but just to add, you know, another cost is trust in government. You know, since 9/11, there are an astonishing number of things that are open secrets that it is impossible for either government agents to talk about or for individuals in court to talk about. And the most recent example is the one that Bill alluded to earlier. The official stance of the Obama administration is that it will neither confirm nor deny that the CIA has a drone program, or that the CIA or that the government itself was involved in the killing of Anwar al-Awlaki. Those are things that are secret in only one place in this country, in American politics and in the courts. And I think it has an effect on Americans' trust in their government when you listen to a speech by Attorney General Eric Holder that talks about something that everyone knows about, and yet he's forced to talk about it in such a way to preserve a need for secrecy that is difficult to explain. And it also hurts in the courts because we have litigation that can't go forward over subject matters that everyone agrees either took place in some version of the way that's alleged, or even maybe in a worse way than that's alleged. And the best examples are the torture lawsuits that have been filed since 9/11, where people acknowledge that something wrong occurred, judges acknowledge that if the facts as alleged occurred, there's something quite significant and troubling, and yet the courts are not allowed to opine on these matters, and Americans are denied a definitive statement about something that strikes to the core of what it means to be American. And I think you can't undervalue the corrosive effect that secrecy has on that basic trust in government.
Liza, you had...
When you were talking about Holder's speech, this phrase sprung to mind: implausible deniability. That's what it is. But the point that I was going to raise has to do with another cost, which is another national security cost. When so much information is classified, so much of it needlessly classified, these days, in order to do just about any job in government, to sweep the floor, you need a security clearance. And so we now have more than 4 million people with security clearances. That is roughly the size of the federal government. I mean, a lot of these people are contractors, but just to give a comparison, it's about 1 in every 50 adult Americans. Of course we have leaks. I mean, we have this huge pool of people, and these are people who day after day after day are seeing documents that are stamped classified that never in a million years should qualify as classified, and so they are losing respect for the system. And so you have this large number of people who have no respect for the classification system with some justification, and the baby gets thrown out with the bathwater. I mean, that's the risk, is that people are going to leak information because they don't think it matters, because they don't think the classified label means anything, and maybe this time they'll be wrong, and there'll be something in there that really shouldn't get out, that really ought to be kept secret. So it just makes it harder to keep the real secrets when so many things are needlessly kept secret.
Liza, you actually brought to my attention a fascinating report that came out last year as a result of a conference that ABA held, and it was called No More Secrets. And the concept was that, in fact, they quote, and I thought it was fascinating, there's someone at the CIA who's called the Intellipedia Doyen, which I just love that name. But he said, in 15 years, there'll be no more secrets. And that was in 2008 when he said that. So we're getting close to sort of in 10 years. The idea being, as you said, there's so many secrets and there's so much capacity for open sourcing of almost everything. Is that a naive concept, that in 10 years there'll be no more secrets?
I mean, I think that was probably poetic license. But
Sure.
I mean, I think the point was clearly true, which is it's getting harder and harder in the information age to keep things secret, and all it takes is one security breach, and in the blink of an eye, 250,000 previously secret documents are up on the internet, and we all know what I'm talking about. And so this secrecy is an increasingly weak security measure, and in any other context, if we had any other weapon, a military defensive weapon that we knew was becoming increasingly vulnerable, increasingly ineffective, because the enemy had developed a technology to counter it, we would phase out reliance on it, or we would, rely on it less, only to the extent that we absolutely had to. But we're not doing that with secrecy.
And a perfect example of that is, with the WikiLeaks phenomena. The challenge is that, at least for national security information, the framework that we use to protect information is fundamentally the same framework we developed for the Manhattan Project over 70 years ago. It's a product of the industrial age. The whole WikiLeaks phenomena presented our government with the perfect opportunity to say, hey, you know what? We have to fundamentally rethink this whole concept of what is a secret, what's not, how do you protect it, and whatever. Perfect opportunity. But yet, what has been the reaction of our government to WikiLeaks? We got to find a way to lock those doors a little bit tighter. We got to find a way to polygraph more people. We got to find absolutely no one, and this is one thing that I find most disturbing, no one is taking a look at that fundamental question: how do we rethink this whole issue in the age in which we are today and rapidly moving into tomorrow?
Bill and Jeff, I wanted to ask you this question based on your background in government. I remember a few years ago when Chris Shays was the chair of the National Security Subcommittee of House Government Reform. He had a witness who was a DOD, I forget what position she was, Patrice may, or some of you may remember this, and she estimated that as much as 90% of what was classified was probably overclassified. I wanted to get your reaction to that. I want to get a sense for all of us, like, how much, we're talking about overclassification, but how much are we talking about is classified really doesn't need to be?
I don't think it's anywhere close to that. The material that I saw, and it may be that I occupied positions where I saw things differently, but it was overwhelmingly properly classified. There is a great deal that's very lightly classified, no great harm would be released, or would be caused if it were to be released, but it's nowhere close to 90%.
Actually, I was sitting next to her when she said that.
Okay, good. Then you can remember.
So, and actually, I don't get that upset over the classified Christmas invitations and, all those sorts of silly stuff like that. I get upset over the substantive things, and quite frankly, the substantive things are very situational. One of the strengths about the framework that we have is that it allows discretion. It allows the use of judgment. And one of the shortcomings we have is that no one, with rare exception, will apply judgment. And I'll give a perfect example. I alluded to before. The decision to invest, to expend the blood and treasure that we have in Iraq, based upon, in large part, upon a national intelligence estimate that the Congress asked to be developed. That national intelligence estimate turned out to be wrong. But as a companion, there was an unclassified white paper that was prepared that most members of Congress relied upon, most people and members of the public relied upon, and there were material differences between that classified national intelligence estimate and the unclassified white paper, not the least of which is in the national intelligence estimate, our nuclear experts at the Department of Energy said, nah, we don't think those aluminum tubes are part of a WMD program. But there was absolutely no mention of that in the unclassified white paper. And when the Senate Select Committee on Intelligence did their review several years later and got into that, the answer they were given by the folks at the DCI and what have you, it sounded reasonable. That, well, we don't like to air disagreements between agencies because that can tip the hand to a potential adversary in terms of potential cover stories and things along those lines. And that's grounds, very clearly that's grounds for classification. However, when it comes to a decision as to whether or not to unleash the brutality of war, I'm sorry, that's a pretty poor excuse to withhold information like that. So it's very situational, and those are the types of things I think where I get most upset about it are the substantive things which carry tremendous consequences, yet no judgment is applied in terms of what do we gain, what do we lose by keeping it secret.
Although, given the last panel that was just such a fascinating panel, would you not think that people would be more worried about erring on the side of making something not classified, given the current, or maybe it's not even just current, but just the environment in government? Are you going to get in trouble for? As
a matter of fact, that was exactly the rationale offered by the Pentagon official sitting next to me, was that the Department of Defense, we're currently fighting two wars, and if we're going to make an error, the tendency is to err on the side of caution. And my retort right in front of Congressman Shays was, that's the first time I've ever heard that that error is an integral part of an implementation strategy. And if there was any time that calls for getting it right and getting it absolutely right, it's when you are in war, because, again, the consequences are severe.
So do you think it's possible to have, as part of a federal employee's performance evaluation, that they're not overclassifying things, so that sort of
based
on
on
the opposite side of where we're going now?
Based upon personal experience right now, I have absolutely no faith in that whatsoever. Many of you probably may know that as part of my involvement in the Drake case, after I had seen what the government purported was classified and actually served as one of the felony indictments of Mr. Drake under the Espionage Act, a document that the government themselves realized that they would never convince 12 ordinary Americans sitting on a jury that it was unclassified. So unprecedented in an espionage investigation, they declassified it before the actual prosecution. After the case was over, I filed a formal complaint with my former office, to the effect that if ever there was a basis in which to hold individuals accountable for improperly classifying information, because the executive order makes no distinction. If you mishandle it and disclose it and you shouldn't, or you mishandle it and withhold it and you shouldn't, it's supposed to be subject to the same sanctions. I says, my point was, if this case cannot serve as the basis for that, then I can't imagine any case serving as the basis to hold people accountable for overclassification. That was 7 months ago, and I haven't heard yet. I'll check my mailbox when I go home tonight.
Jeff, something you said that really struck me. You were talking about, but that stuff that's lightly classified, there's no real harm if it gets out. Can we explore that just for a minute? I mean, do you think that maybe there should be some thought put into the lowest of classification and maybe it doesn't need to be classified anymore?
Of course, and part of it is temporal. One of the curses of this business is, if you're working on a particular project and it's classified secret at this level, sort of everything that is under that gets that same stamp on it. And clearly at the fringes of that, it doesn't really matter. But it's an effort to declassify it so the whole thing is classified secret. And after a while, that moves off your desk and you're on to the next problem, and it winds up in the archives and it's classified for 20 years. And we aren't willing, I'm involved in some other matters now, to try to declassify some old papers from a previous administration. And because of budget cuts, we have fewer and fewer people devoted to declassification. So we're caught with trying to get old stuff declassified, for which there frankly is, I'm not sure what's in the boxes that I'm currently arguing with the archives about, but it's hard for me to imagine it's really classified because it's so old.
In your arguments that you're making, do you have a suggestion on how long things should be classified for?
No, not how long it should be classified. There are things that I could understand could be classified for 50 years. The identity of a human source, for example, some technical collection things that oddly enough still work today, or people, you have a system that was developed 70 years ago and keeps being refined, and if somebody knew that we could do something 70 years ago, we can still do it today, but you have to be able to make that case. Just to sweepingly say that it should remain classified is a big mistake. The answer, frankly, is manpower, and one of the things I've been thinking about is could private interests could libraries or foundations provide money to the government to hire people to go through and review old documents and release them? Or is that an illegal supplementation of appropriations which is prohibited in some way? It's just so frustrating that these old documents that are of historical value are sitting in a box marked secret or top secret or higher.
I want to stay with you, Jeff, for a second. You sponsored something that was really fascinating to me, which was a dialogue between people inside the intelligence community and journalists on setting some sort of ground rules, as I understand it. Have these recent prosecutions sort of thrown those rules out the window, or where do things stand with that? And you can describe that process.
I'll do it very quickly. It was Scott Armstrong and myself teamed up many years ago, and Dana has participated in this, and so have some others. And the idea was to get journalists and members of the national security community talking to each other off the record about how you handle these things. Because this is one of these things where there really isn't a good answer. The Constitution has left this, in my judgment, intentionally vague for the reasons we've talked about. So we would convene dinners where we would just talk about things. We would have people come in and talk to us. At one point, we've had some very senior people come in and say, here's something that should remain secret, and the press has said here's why it shouldn't be. But basically the idea was to get the two communities talking to each other, so when something would come up, there could actually be an intelligent discussion between an editor and a publisher and the National Security Advisor. I think it worked pretty well. We had another session out at Aspen, sponsored by Aspen last spring, about almost a year ago now, and reassembled many of these same players. I think it's been helpful, but I defer to Dana and others as to whether it's made any progress or if we just had some nice dinners and talked to one another.
Yeah, I think the latter because, or the former, because given the last experience we had with when we did the series Top Secret America for the Washington Post, we went to the different intelligence agencies to brief them on what we had assembled in our database so that we could have an intelligent, civil, professional conversation about if they had any concerns about what was in there. Maybe they would want us to pull back some things, and we would listen and definitely consider that. And after a long time and a lot of effort going through this, they basically came back and said, well, we have no comment. And that is a ridiculously infantile. And then what happened was some of the agencies that had a better relationship, and this is very personal. It's a personal relationship. What you're doing is you're building trust. You can't between individuals. And when those individuals on the government side leave and new ones come in, you have to start over again. So there were some agencies that sort of went by themselves and said, well, we'd like you to consider not putting this one thing in there because you don't have the whole story. It's really very sensitive and blah, blah, blah. And so, we did that in a couple cases. But we had to make our own decision without the government, which we had started to do anyway, about what was proper and not proper to put in the paper. And so we came to our own conclusion even before they came and said no comment. But I could tell you other stories that are really pretty funny about the CIA when they had the turnover between Goss and Tenet, and their public affairs people were very new, and we came with a pretty sensitive story, and they said no comment. I'm not going to say, don't you want to ask me not to put that in the paper? But we ended up not putting a lot of the details of a certain thing in the paper.
But you have to make that, to just follow up,
right.
The problem is you're trying to make that judgment without the government telling you why something is sensitive. And I think that's just foolish on the government's part, frankly.
Dana, to stay with you just for a second, one of the things that I found particularly interesting in your series was the role of contractors in the shadow government, the secret government. If you could talk a little bit about that and the impact of the privatization of the sort of intelligence world.
Well, you all know that the contracting community around national security has grown so much, in large part because Congress said, have these tens of billions of dollars more for counterterrorism, but don't grow the size of government. So there's only one option, which is contracting. And contractors were supposed to do the support activities, but really they do almost everything, including being involved in covert action. 8 of the 22 anonymous stars on the wall of honor at the CIA are actually contractors who died in line of duty. So they are in there doing the most fundamental things that government does. Leon Panetta, at the time CIA director, when he talked to me about this, his concern was that he had a little less control over them because they have a loyalty. They have to have a loyalty to their company because that's who employs them. And the company, no matter how patriotic the individuals in the company are, usually don't exist without making a profit. So that puts a different dynamic in there that is not necessarily good for good government. I think the government's trying to deal with this, but has found that it's very difficult. One, they don't have the information about where the contractors are. They're still gathering a lot of that. And then what are you going to do in this time when budgets are being cut? Are you going to actually say, if we lose 100 contractors, can we have 10 real employees, more than we have now? Politically, that is going to be very difficult.
Challenging. Before I turn it open to questions, I wanted to ask the panelists if you feel, first of all, do you feel a need to curb this monster, or maybe it's not a monster? Some of the concrete solutions I've been hearing so far is the specific fix to FOIA that Alex referenced, possibly working to make sure the OLC opinions are not secret, more oversight of Title 50, more manpower for declassification. Are there other things that you're thinking of? Or maybe Jeff, you don't think anything's wrong?
No, of course something's wrong. But fixing it is going to be hard. Bill may have more concrete suggestions than I do about what could be done.
Well, I mean, some of the things that we're seeing I think are very concrete, or the IGs and the agencies are getting specifically involved in things along those lines. One of the things that's debated back and forth and never been realized is, in terms of helping empower Congress, would be to empower GAO to get involved in greater oversight over the intelligence community.
And get that legislation passed.
President Obama threatened to veto that legislation.
Yes. Dan Ashby's legislation, right? That was great.
So, exactly. But that's an example. The solutions are out there. I mean, there really are. But there's it's a protection of prerogatives and what have you.
Was there any other specifics before I open it up?
Well, I think y'all need to go buy more newspapers so that we can hire more national security reporters, because I don't see these things being fixed by government unless it becomes politically necessary to do. And I don't see that happening anytime soon. So really, in this contest where there is no solutions other than the ones we have, and part of it could be to want more information, and you're not going to get it in other places.
And I would be remiss if I did not say, on behalf of my organization, that we've looked at the overclassification problem in a fair amount of detail, and I think not just for overclassification, but across the secrecy, across top secret America. I think that, at a minimum, a starting point is to try to ensure that the tools of secrecy are used more appropriately and more responsibility. And what that is all about is accountability. So, at the Brennan Center, we came out with a report suggesting some means to hold classifiers accountable for overclassification, some very basic measures, having them actually identify the national security harm that could result from disclosure, having spot audits that are conducted by the offices of the Inspector General, and having follow-up audits and some mandatory consequences for repeat offenders. So that's not simply to sort of promote my organization's one specific solution, but more to say more generally, there is room, I think, to push for more accountability in the way that the current tools are used, and then there can be a broader conversation about whether those are the right tools and whether we need to think more holistically about how we're going to approach national security and secrecy in a world where it's increasingly difficult to keep secrets.
And that's why I want to publicly state that if there fails to be accountability with respect to the Thomas Drake case and the abuse of classification, quite frankly, I despair for the system.
and I would certainly be remiss if I didn't point out that at the moment, intelligence agency employees and contractors really have no meaningful whistleblower protections, and that's something that we're striving very much to have, because frankly what happens is then, as a result, they're forced to go outside to the media to try to correct wrongdoing, because there isn't any safe way of doing it internally.
I don't know enough to question that, but I do question it.
Tell me why.
Because my sense is that the agencies have ways, I'm told, I have had no direct experience with this, but I've been assured that if an agency employee, and CIA, but I know best, wants to go to the IG with something, he or she can do that, and they're supposed to not suffer any harm. And if that is not working, then I just am not sure.
It's not working.
It's not working.
I actually
Okay.
talked to Mr. Helgerson, who had been the CIA IG about it. In his 10 years there, only 7 people went and used it, and there was sort of no.
Is that right?
And again, the whole Drake case that dealt with that. He went to the IG.
And more specifically,
All right, I take it back.
I wasn't going to let that one sit.
The Whistleblower Protection Act doesn't cover intelligence and national security employees, and the Intelligence Community Whistleblower Protection Act doesn't protect them against retaliation. Right. That is part of the Whistleblower Protection Act, but not part of the ICWPA.
Right.
So
there is a
gap.
WPEA that we're trying to get passed, which has not yet passed. Anyway, I'm going to open it up for the rest of you to get to engage in the conversation with these fabulous panelists. And go ahead. If you could say who you are, because this is not a secret environment.
My name's John Judge, and I work with a national coalition on political assassinations, so we know about secrecy. We had used the Freedom of Information Act in court suits for 30 years to get maybe 10 or 20,000 pages loose. We eventually worked to get passage of the JFK Assassination Records Act, which took the decisions away from the agencies on release, while holding agent identities and current sources and methods and a limited number of things in place. And we've gotten so far over 6.5 million pages. And I think it's a pernicious sort of situation, because you have over 15.5 million pages a year that are newly classified, and that's just the paper records. You had a forum here with some of the people from the Declassification Center, and they were concerned because there is now a petabyte of information in digital form that's being classified. So much information that there's not time for humans to read it.
Do you have a question, though?
Yes. I just think that that FOIA hasn't done it, but we've been stonewalled on this. We're trying to get a legally mandated hearing in Congress about the JFK Records Act. We have a Martin Luther King Records Act that's pending, and these are congressional records, so they're even harder to get at than
I need to ask
than
you
the
to get
others.
to a question, though. Is there a question
Well,
for the panelists?
I'm just summarizing because I think that you need a different model than the FOIA to eventually do anything about secrecy in this situation.
Any reactions to that? No?
I would just say that the JFK assassination records is an example of how the system can't be dependent upon itself, and that took direct congressional actions. I'd agree.
Go ahead.
My name is Jonathan Keel. The discussion we had earlier about congressional oversight and kind of this frustration that there wasn't sufficient oversight and Congress seemed to be somewhat impotent to actually provide some kind of oversight. Do you fix that? I mean, it would seem to me that it's Congress's role to fix that by legislating additional authority to themselves, essentially. I mean, and I guess my question is, are we expecting the executive branch to voluntarily go over and say, we want to tell you stuff more, but you can't tell anybody? Or, what's the solution to that?
That's a great question.
I'd be interested in my colleagues. My sense is it's for Congress to use the power they have.
Yeah.
Yes.
They've got plenty of power, but I think are reluctant to use it for a whole range of reasons. And having been on both ends of congressional oversight, when Congress gets after you, it's miserable. So if they'll just do what they can do, the executive branch will respond.
Sharon.
Hi, I'm Sharon Bradford Franklin with the Constitution Project. So part of your topic today is about the secret information, the problem of overclassification, which I agree is a huge one, but also you've talked about a secret law and secret interpretations of the law and the denial or refusal to even disclose the existence of programs, so we can't have a public debate on the existence of these programs, such as the NSA warrantless wiretapping program, coming down on that side of the, what we call it, rather than terror surveillance program. But I'm wondering if you can address, it seems to me that that is even more corrosive to government and in some ways just more of a big problem to the public when we can't even know the existence of these programs, debate their legality. Obviously the facts of what they're finding, the evidence on a given suspect, it can be appropriately classified. But if you can address how we might be able to push back on this problem of secret legal interpretations of Section 215 or getting those programs disclosed and aired in public debate.
One way is through the courts, and we've talked a little bit about the courts, and no one seems to have too much faith that they'll change their approach to these cases in the FOIA context. But we'll see in the next few months whether that is the case with the Section 215 case and with legal memos relating to killing U.S. citizens abroad. But it's undoubtedly, an extraordinarily big problem. When Americans can't debate the meaning of laws, when senators can't discuss the meaning of a law with fellow senators who don't happen to be on the same intelligence committee, it's an extremely big problem, and it doesn't seem that Congress is going to provide us a fix anytime soon, but I think we can applaud the efforts at least of Senators Wyden and Udall in this one area for bringing the problem to light and forcing it, forcing us to have a little bit of a debate about it. But, from the ACLU, I'm a big fan of the courts, and I think we have to rely at some point on the courts to assume the role they have to in this area, and it might be that we're seeing a trend that Bill has identified. We're sufficiently removed from the latest crisis that the courts will, resume their previously more rigorous oversight of the political branches.
You have another mic over there.
Where? Oh, I'm sorry. Yes.
Good afternoon. I'm Lois Tett. The phone tap situation engulfed me and a lot of other small business owners. They tapped our phones for no apparent reason, and some of us have to travel overseas because we are doing business there. And I'm wondering, if you haven't been over there before, how can you find out whether or not you are on the travel no-go list? And another thing, I think we need some more discussion on stop loss. A lot of the military guys who are affected by this know nothing of it. It points out the military as nothing but indentured servitude. Because those guys, when they're expected to get out of there, they're suddenly told, oh, we're sorry, you got 4 more years. And they go to pieces. There was a panel on this here. And the lady went to a congressman and everything. Her son was even wounded. That's the only way he got out. So please discuss how I can find out whether or not I'm on the travel no-go list, since they were low enough to tap my phone.
Okay. Any?
I can answer the first part of your question. If you truly are on the no-fly list, you will be turned away from the airport. And if you are turned away from the airport...
I've already gone out there and found out. Is there a number or something I can, because what I really don't like? I mean, I'm handicapped. I got to get out there and then find out, oh, you can't go. I'm not doing that.
You can file something with DHS TRIP, and you can ask for a redress. If they turn you away, you can come talk to us at the ACLU. We have pending litigation about the no-fly list. We'd be happy to talk to you.
And you can tell me where I can call to find out before I go. I don't want to go.
Alex gets
your
card.
In a few minutes.
All right. Yes. Good. Thank you, Alex.
And on the stop loss issue, I feel very strongly about that. I began life as an infantry officer, and I think it's a disgrace that we don't have more people willing to serve this country, and that we have, and it's not the fault of, there's a lot of faults here, but if we're going to go to war, we ought to think about the draft. And to ask volunteers to take 4, 5, 6 tours is just wrong.
I appreciate that.
Thanks for all your insights. I especially am directing this question to the journalists on the panel. Lisette Garcia, Judicial Watch. Sorry about that. So I guess I'm wondering how much journalism is willing to take some responsibility for fostering a culture of over-secrecy among government bureaucrats. And what I mean by that, recently I obtained a document where it was a media briefing about a new agency that was started under Dodd-Frank. And so this goes as much to the previous panel, where 5 different mainstream media sources had individually granted the agency off-the-record permission, non-sourced, to the head of the agency, so that an expository story was completely done based on the terms that the PR person had set from within the agency. So to the extent that anonymous sourcing is de rigueur anymore, it's not a special case, only whistleblowers, but it's just pretty much almost every story you read in the Washington Post of any substance and significance is anonymously sourced. Are we not, in fact, giving the government permission to encourage an over-secrecy?
Dana?
We don't have a lot of leverage in this regard. USA Today at one point tried by just saying we will not write stories that are not quoting somebody, and they actually got some agencies like the Defense Department to pony up somebody and quote them. But when you're dealing with the intelligence world, when I first got into this, I made the mistake of thinking that the military world and the intelligence world were somewhat similar, and they're not at all. So I just don't have much hope that if you're not willing to grant anonymity to a briefer, especially someone that's being officially given to you, because you're probably not going to get much anyway from that person, but you're just not going to get the information. And I don't know. I guess if you band together and did it that way, that might help. But then again, they just might freeze everybody out because they mostly have no interest in briefing us.
All right. Well, I'm sorry, but we have run out of time. I want to thank the panelists for a really fabulous discussion, and OpenTheGovernment.org and the Freedom Forum.
As always.
Thanks very much.
Thank you. It was really fun. Thank you.